may be seated. Remain quiet, please.
On behalf of the people.
Good morning, Your Honor. For the record, Steve Mikowski on behalf of Mr. Charles Hammond.
All right, Mr. Mikowski, today's the day set for final conference. We've got a trial date of October 26th. Anything I can do to help move this along?
Judge, I think that this may eventually be resolved, so we would just keep it on track for our trial date.
All right. I won't set any other controlling dates then?
I don't think so, but we may well be coming back to ask for one.
Okay. Well, just let us know. Your trial is less than 2 weeks off. Right. Okay. See you on the 26th.
Thank you.
Thank you.
What are you doing about this trial? Is that...
Supervisor, Ms. Miles, so they're...
Did we confirm a jury yesterday?
Well, I did.
Oh, did you? Okay. Nobody did. I just still really overlooked it. I don't know what I'm doing with this thing on Thursday. But, okay.
So I did. So.
It's Gabi and, okay. They're trying to work it out.
Okay. Okay.
Okay. We really need to get this sentencing on Montgomery thing done.
That's what we're
I
about
mean,
to do.
there's 15 deputies here.
That's what we're about to do.
Okay.
It's coming. They're going to jail.
They're going to get him now?
Mm-hmm.
Let me talk to Wyatt and Danielle. It's Danielle and the... It's,
Ms. Hagerman Clark, Mr. Harris, can you approach, please?
oh, let's get back. Come on back for just a second. Court's back in session. Remain seated, please.
Mr. Montgomery?
Good morning, Your Honor. Danielle Hageman Clark on behalf of the people.
Good morning, Your Honor. Wyatt Harris, retained counsel on behalf of Mr. Montgomery, the Assistant Defense Counsel, table P number P54898.
And good morning, Your Honor. Harold Collins, appearing as co-counsel on behalf of Mr. Michael Montgomery, who is seated at the table in front of the prison.
All right, we're here for sentencing on this matter, and of course there is a sentence agreement here. But Mr. Harris, I assume you've had a chance to go over the pre-sentence report with Mr. Montgomery.
Yes, Your Honor.
Are there any deletions, changes, or amendments to be made to the report?
No, Your Honor.
All right. Are the jail credit days calculated accurately? They look like they are.
They appear to be accurate.
Yes, they are, Your Honor.
All right. Well, not to put too fine a point on this, but, you know, if you look at the range of dates, it's October 20th, 2015 to October 12th. That's a little less than a year, but they're calculating 380 days.
I think it's probably 309, Your Honor. I think it's calculated properly on.
No, well, it would have to be nearly 365 days, wouldn't it?
So if you look at the third page of the report, where it indicates arrest, page 4 of the body of the report, it indicates 309. I think that's...
Well, they've got an arrest date. Of course, it depends on the case, I guess, but when was he arrested on the first case? Was that October...
I believe it was October 20th.
20th, okay. So he gets credit from October 20th until today. But that's a little less than one full year. Because today's the 7 days less than a full year.
So it should be
358 days, shouldn't it?
correct. That's correct.
If the dates are... Well, and then they're not counting today, of course. So 359 days, I think, would be the right number. I don't want this coming back on a arithmetical issue. But you see what I mean, Ms. Hageman?
I do, Judge.
So can we settle on 359?
Yes, Your Honor.
Sure.
All right.
And I also just looked at page 4, Your Honor. It says 12/9/2015, and it should probably be 10/20/2015.
Well, he may have been technically arrested on some of these cases after he was in custody on the first one. And that may account for why the arrest date is different on the case ending in 6507. That isn't going to make a difference in terms of the calculations. I think what we need to do is go back to the first day he was in custody, which I guess by all accounts is the 20th of October. Okay. Now, what about guidelines? I know there was a sentence agreement here, but let's just make sure we're all in sync on what the guidelines are.
Judge, the only correction I have to the guidelines, and it's just, it doesn't change the guidelines because I think that they just need to be swapped, is offense variable number 12 on the assault with intent to murder guidelines are currently scored at 25. That should be 0, and offense 13 should get the 25 points. So it's just a matter of...
Yeah, because you can't score 12. Okay.
No
And-
objection, Your Honor.
All right. Same bottom line. Okay.
Yes.
All right. Anything else?
No, so then those guidelines still remain 171 to 285?
Yeah. Is the 285 the habitualized number?
No, because the defendant wasn't habitual.
Ah, yes. Okay. All right. So we agree it's 171 to 285.
And then,
of course,
yes,
there
and
was
on the second-degree murder, the guidelines are 225 to 375.
Right. Righto. Okay. And then, of course, there were some consecutive sentencing options here, which were not part of the plea agreement, and a charge reduction from murder 1 to murder 2 in the homicide case. So we're good. All right. Ms. Hageman Clark, are there any complainants or victims who wish to speak?
There are, Judge.
Okay.
I would note for the record that Ms. Gay is present in court and does not want to address the court, but she is here. the family of Ms. White is here and may like an opportunity to address the court. But I know that Ms. Adams is here and would like an opportunity to address the court at this time.
Okay, you can call them in whatever order you please.
Ms. Adams? That was it.
Ms. Adams, I think we're going to have, because we are fairly crowded, why don't you step out of your row and stand over there near Ms. Hageman.
Do you want her on this side of the bench or that?
Well, if it's more convenient for her to stand on the other side, is that be okay for you?
Think it's good?
Yeah, that should be good. All right.
Can I give him this? Can he look at this while I come through? Can he have that, please?
Yeah. Well, no, we don't want to do that.
No?
Just address me.
Okay.
Okay. Thank you, Ms. Adams.
Okay, well, I wrote it down so I don't...
By all means, handle it
Okay.
any way you please.
Well, I just figured that he should be introduced to me. Consider
Ms. Adams, would you just allocute, please?
I absolutely will,
Okay.
sir. My name's Kelly Adams. I'm a mother. I'm a medic. And my life matters, and that's why I'm here today. I've been working for the city of Detroit for 14 years, up until last year, on October 20th. Mr. Montgomery is a criminal. He's a rapist. He murders children. He's a psychopath that tried to kill 2 medics that were just trying to do their jobs because he couldn't get a free ride in an ambulance. But he's going to get his free ride today. 4 years of a free ride. Now, for the record, I don't think justice was served. I think he should be getting life sentences for each and every count that he had. That's my opinion, and I'm entitled to it. But like I said, justice wasn't served. The police dropped the ball, judges, Kim Worthy's people, everybody that worked on this case let this slip right through. There's no reason he should be in 40 years for 6 counts of what he did. He's destroyed the Johnson family. He's maimed me for the rest of my life. I have scars and mental issues that are going to go on for the rest of my life, but I'll be all right. He got all Freddy Krueger with us, me and Rojas. But he didn't win. But he cut us bad enough that the both of us almost died that night. But we didn't die. And he's not a free man anymore. He won't be a free man for at least 40 years. And I believe anyone that helped him through these 10 years should be hanging their head because they know what a psychopath pedophile this man is. But they insisted on helping him. He needed help, yes, but not to get out of a murder case. This little girl doesn't have a headstone. She lays in a grave with a marker. I got a real strange feeling when the city catches up with them test kits that they are so far behind on. His nastiness is going to be all over them, just like everyone they test now. And I hope he has to be tried for those. I hope. But if this is any... No, let me stop with that. Like I said, Rojas and I should have been dead, but we're not. Because we fought together, because that's what we do. I made sure he went home, and he made sure I went home. And let's make sure this man stays in jail Just a little bit more than 40 years. Because that was a slap in the face to all of us. Me, Rohan, and the Johnson family, and the girl that didn't show up. They don't show up for a reason, and it's because they're still afraid of him. In no way, shape, or form was I ever afraid of this man. And I'm still not. But again, I think y'all failed us. And that's all I got to say.
All right, well, thank you for sharing those thoughts. I'm very sorry for
Thank you.
your losses, as I am for all the families. Okay.
It'd be nice if you knew how to look up.
All right. Ms. Clark, are there any other victims or family representatives that wish to speak?
Just one moment.
Yeah.
Danielle. Mr. Rojas, would you like to speak? Okay.
Oh, do you want to speak? Okay, very good.
Tell us your name.
My name is Alfredo Rojas. I actually have nothing to say to him, but I was asked to come up here by family of another victim to speak on their behalf. So it says, justice for Charnel Irving. This monster's victim in 2015, whose case was dismissed because she is mentally impaired and cannot understand the questions the attorney was asking her. She was kidnapped, beat, robbed, had a knife placed to her head. Thank God she was able to set herself free. He went back to finish her, but God is good because she was not there. Justice for Charnel, justice for Charnel, justice for Charnel, justice. That's it.
Thank you, sir.
My name is Lorenzo White. Dantoya White was my niece. She was only 15 years old when you took her and killed her in that alley. You mutilated her body. You just didn't kill her. You took her soul. You took her soul. You should not, 40 years is not enough. He should be able to get the maximum. You took her life. You took our life. You want to cry on TV, but you cannot look at us while we're talking. But, Your Honor, he should get the max. He harmed more than just one family, more than two, more than three. But, like again, when the rape kits come out, it's more people out here. He think he got away with, but he hasn't. But 40 years, that's a slap in the face. For the way he did my niece, cut her up, stabbed her. You can see her mouth through the side of her face. Her vagina area dismantled. This, may God rest your soul.
All right, thank you, sir. We're very sorry for your loss and your family's loss as well. Are there any other victims or complainants or representatives?
Judge, I'm not aware of anybody else from any of the families that wish to address the court at this time.
All right. Anything else you'd like to say by way of remarks, Ms. Edmond?
Judge, I just wanted to respectfully disagree with Ms. Adams' assertion that the police failed her in this particular investigation. I believe that it's only through the continued and diligent efforts of the Detroit Police Department, particularly in the sex crimes unit as well as in the homicide unit, that eventually we're able to figure out who it was that had done all these terrible crimes to all of these families. And through DNA evidence, they were able to track the defendant in Dakota. He went, and that's where it was ultimately decided. The police were hunting for the defendant at the time that he attacked Mr. Rojas as well as Ms. Adams. And so I do think that it was only through their continued efforts that the defendant was ever able to be identified and linked back to all these awful crimes from 2005 and 2006. Fortunately, his reign of terror is over, and I would ask this court to sentence the defendant.
Very well. Mr. Montgomery, do you have anything you'd like to say before I impose the sentences? All right. Mr. Harris?
Your Honor, we'd ask that you impose the sentence agreement that we have with the prosecutor. This is obviously very tragic for a number of things, difficult for the victims and his folks, and I'm sure it's difficult for their family. It's difficult for Mr. Montgomery's family. They are very hurt by all of this, and Mr. Montgomery understood that he could not put his family through a trial, and that is why he agreed to this hearing, to want to save himself and save his family, to testify in this matter. That's what you sentence him in accordance with the court.
All right. Well, I think Ms. Adams raises some points that really should be addressed before I move forward with the sentencing. I know that she's very bitter and disappointed about this entire set of circumstances. She suffered, of course, an extremely severe and disfiguring injury while she was just doing her job. It was that incident that brought the defendant into custody. I certainly can't imagine any legitimate criticism of the way law enforcement handled that case. There has been some criticism in the media about the handling or the investigation of some of the older cases, and there's always two sides of that, and that's not an analysis that we're obligated to talk about today anyway. The fact of the matter is that in the end, Mr. Montgomery was charged in 4 separate cases, all very serious, gruesome, awful cases, and I don't know that any objective observer could criticize in any way the way the prosecutor's office handled the case, or how any level of the judiciary handled the case. There is often in cases with high profile and awful facts a sort of generic criticism of sentence agreements, but the public has to understand that the sentence agreements reached in this package of cases involves a term of imprisonment in which the defendant won't even be eligible for parole review until he's 71 years old, if he lives to be 71, and the maximum sentence involved here involves him serving well past his 100th birthday. So expressions of bitterness or disagreement with the terms and conditions of the plea and sentence agreement in this case are really far-fetched. The fact is that Mr. Montgomery did, in the end, own up to his just egregious behavior in these cases, and as a result of the plea and sentence agreement in this case, the public and the victims and the victims' families were spared the ordeal and anguish of going through 4 separate trials. And I know from my experience sitting here that trials in cases like this can and usually do involve a tremendous amount of personal anguish and pain for everyone involved. And so I just wanted to make that remark in endorsing the people's efforts, the prosecutor's office and defense counsel, in arriving at the conclusion that we're going to finalize today. I compliment you both on being able to do that, and I think ultimately it represents the justice system at its best, contrary to what some commentators may say. So, my compliments to both of you on being able to work this out. All right, Mr. Montgomery, it's going to take me a few minutes to announce your sentence in this case because there are 4 different cases and a number of different charges. First of all, in the case ending in 0038, where you pled guilty to second-degree murder and criminal sexual conduct in the first degree, I am remanding you to the custody of the Michigan Department of Corrections for prison terms of no fewer than 40 years and no more than 80 years. Those sentences will be served concurrently. Then on the case ending in 0039, where you were convicted by a plea of 2 counts of assault with intent to murder and 2 counts of resisting, obstructing, or assaulting a police officer. On the assault with intent to murder counts, you are sentenced similarly to concurrent prison terms of no less than 40 years and no more than 80 years. On the assaulting police officer counts, you're sentenced to concurrent terms of no less than 10 years, no more than 15 years, and there was also a count of assault with intent to maim, which is a 10-year felony, and in that case I'm sentencing you to a concurrent term of 5 years to 10 years. Then moving on to the case ending in 0040, where you pled guilty to 2 counts of criminal sexual conduct in the first degree and 1 count of kidnapping, I am sentencing you to 3 concurrent prison terms of no less than 40 years and no more than 80 years. Then in the case, finally, ending in 6507, where you were convicted on a plea of 1 count of kidnapping, 1 count of criminal sexual conduct in the first degree, and 1 count of torture, you are sentenced again to concurrent prison terms of no less than 40 years and no more than 80 years. And just to be clear, all of the sentences that I have just announced will be served concurrently, and they are largely subject to a set-off or credit of 359 days in all sentences except the last 3 I mentioned. For the case ending in 6507, the credit is 309 days. In all other cases, it's 359 days. Mr. Montgomery, you've got a right to ask the Michigan Court of Appeals to review your pleas and sentences in this case. You don't have an automatic right to appellate review, but you have a right to ask for it. And if you are unable to afford a lawyer, a lawyer will be appointed for you at public expense, and the lawyer will be provided with a copy of the transcript of today's proceedings and anything else out of the court file that the lawyer may need in order to manage your appeal. You're going to be given a form to sign in which you acknowledge receipt of the rights that I just gave you. It is a copy of that form that must be filed with the clerk of this court within 42 days of today's date if you intend to seek appellate review and get an assigned counsel. Anything further?
Yes, Judge. Part of the sentence agreement is also that the defendant, if he is ever released on parole, that he has to be tethered by electronic monitoring for the rest of his life.
Lifetime electronic monitoring, right.
And he has lifetime sex offender registry.
Absolutely, you're right. So if and when he's ever paroled, those conditions will apply. All right, anything further from either side?
Not on behalf of people.
On behalf of the defense.
All right. That concludes this matter. Thank you. I'm glad we were able to get this early.
Yeah,
They come out of other courtrooms.
have to pull up resources.
Yeah.